presentation, so hopefully you will all be able to see the slides. And then we can get going. First of all, if I may just introduce myself. I put a picture up just as it's rather strange. I'm sitting in a room all by myself, and I imagine many of you are doing the same. Wrigley's is a specialist firm. We deal with charities and social enterprises, all shapes, all sizes, pretty much across the entire spectrum of the sector and across the country and internationally. My work at Wrigley's covers legal structures, contracts and employment. In terms of legal structures, which is the focus today, the issues that I tend to deal with are trying to identify what might be the most appropriate legal structure for any particular circumstances. There are a number of options available, although when you do look at the legal structures of companies that you might come across, they tend to fit into quite a narrow band of those available options. So even though circumstances for particular groups, particular individuals may differ, the end result in terms of the legal structure that works for them means that you do end up in this rather narrow section, and I'll touch on which those company structures are as we go through the presentation. The key is just to recognize that there are a number of options out there. Each of the legal structures give you slightly different advantages or indeed disadvantages over other structures, but what works best for you. And it's worthwhile looking at that point at the start, because whilst it is possible to change your structure as your business, your organization develops, it's a lot easier and certainly a lot more cost effective to get the structure right from the start. What I also want to do is just outline some of these issues over what is the difference between the status of a structure and its actual legal form. And then, as I say, I will go through what those available forms are, looking at some of the key features, advantages and disadvantages. Social enterprise. I'm often asked, given the nature of the work that I specialize in, an individual will come to me and say, I want to be a social enterprise. My question back is, well, that's all well and good. What do you actually want to do with it? I've put onto this slide a definition of social enterprise. Now, there are those who can spend days actually discussing and not reaching agreement on exactly what is a social enterprise, but this definition came out of government in 2002, and it's what central government works with as a definition, and it's one that does fit most but not all definitions used around social enterprises. And you'll see from it, I won't read it out, I'm sure you've read it already, you'll see from it that it actually talks about what you do and how you do it, rather than the structure that you use. So from my point of view, any of the legal structures that I'll touch on can be used for social enterprise purposes. There are some that are better suited than others. Some have advantages, some have disadvantages. But you need to recognize that social enterprise is more about status. It's not actually defining the structure that you're using. And the same applies for charity. This is the legal definition of a charity. It's about what you do. It's not about what kind of structure you have. And again, certain legal structures are better suited for those that may want charitable status, but it's about what suits your particular circumstances. So what are the legal forms? This is the spectrum that we work with. Working from the top, the unincorporated associations, down to the charitable incorporated organizations at the bottom, and that actually gives you a spectrum of time history as well. In sort of legal history, the unincorporated associations have been around much, much longer than the charitable incorporated organizations. In fact, we anticipate the new regulations for charitable incorporated organizations to come out in 2 weeks' time. So that is a very new legal structure designed, as the title suggests, specifically for those that are looking for charitable organizations. Now, as you go down that list, the type of structure, the type of legal form differs between unincorporated and incorporated. And that's an important distinction which I'll touch on. Let's just look at the unincorporated structures to start with. Now, these are often your clubs, your associations. Now, they can be members clubs, it could be a golf club, it could be a gym, it could just be a trade association bringing together individuals or indeed other businesses into a single structure that has a common purpose. That's the binding glue in these kind of relationships. You have a group of individuals and organizations that have a common purpose. There is some advantage in them working together, but they create something which is more than just a disparate group of individuals. They create a coordinated group, and they do that through some form of written constitution, written rules, or indeed a deed of trust for unincorporated trusts. And all that document does is sets out what the various members of that association have agreed will be the standing orders for that particular association. So it's things like who can be members, how do you appoint members, what's the purpose of the association, who's going to run it on behalf of the members, are you going to appoint some trustees, are you going to appoint a management committee, how is it going to be internally organized, how will you have elections, and ultimately, one hopes, how do you deal with the issue of removal of members and ultimately dissolution of the association itself, so that when its purpose has come to an end, or indeed the members have decided that it's no longer fit for purpose, how do you bring it to a close? And all of that is dealt with in a simple set of written rules. There's nothing more formal about it. You can do what you want with it. But that's the starting point for any kind of legal structure. Now, the difficulty with that kind of structure is that it is, in law, simply that collection of individuals, so that those who stand as representatives of that organization do it on a personal basis. That carries with it personal liability. And the key feature of the unincorporated structures is that those involved have potentially personal liability for any of the liabilities that that association may create. Now, that could be that it enters into a contract to deliver services, it buys a property, it employs somebody. That's a contract that carries with it a liability. Somebody has to sign that contract on behalf of the association. Even if it's not a written contract and it's just an arrangement that comes into effect, somebody has to take on the responsibility on behalf of the association. And whoever that is, they have a personal liability. Now, the rules, the Constitution or the deed itself, may well have provisions that indemnify anyone who incurs that kind of liability. But what that means is that all of the members will have potentially unlimited liability for the acts, the omissions, and the liabilities that arise in relation to the activities undertaken through the association. So it's a very, very flexible structure. It's a very common structure, but it is also a very risky structure because of the liability. And I put down here some examples of where we find trusts and associations being created, very often used in charitable foundations, religious trusts, but as I say, even a local gaming club, a bridge club, could be an unincorporated association with that potential for personal liability. In the business context, the equivalent to an unincorporated association is a partnership. Now, partnerships are governed by the 1890 Act. That just shows how relevant and up-to-date the Act is. But what's important is that, again, there are no formalities required for a partnership to exist. As soon as you have two or more people who have some relationship in business, in common, with a view of making a profit. Doesn't matter what they want to do with that profit. It could be wholly charitable purposes. But as soon as they're trading with a view to profit, a partnership exists. Now, again, the issue here is that this is an unincorporated association. The individuals involved have potential personal liability for everything that that partnership engages in. There's an old adage which is, choose your partners carefully, and it applies because of this particular relationship. Whatever your partners do, whether you know about it, whether you authorize it, whatever they do that is done in the name of the partnership carries a liability for all of the partners. So when we're looking at legal structures, we look principally at this issue of unincorporated and incorporated status. What's the difference? What are the advantages? Well, as I say, the advantages is that it's very, very easy to set these things up. They're very informal, and in the case of the partnership, it's sometimes too easy. You can suddenly find yourself in a legal partnership relationship without even expecting to be so. That carries with it the personal liability. On the flip side, for the incorporated structure, is that an incorporated company will give rise to what's recognized in law as a separate legal identity. It's often referred to as having limited liability, and that is one of the key features, because those involved in an incorporated structure do have limited liability, and I'll touch on exactly what that means in a moment. That comes, though, at a price. Often it's not seen as being an excessive price, because in order to gain advantage of incorporated status and limited liability that comes with it, there is more regulation. You're governed by whatever statute it is that deals with the particular structure that you've chosen. They always involve some element of disclosure. So with companies, there's information that you are obliged to send to Companies House. And there's also the risk, if you don't follow those rules properly, that the limited liability can be lost. Now, the limited liability is exactly that. It's limited. It doesn't mean to say you have no liability. It is limited liability. And the reason that is available to an incorporated structure is, as I said, this point that an incorporated structure, a company, I'll just use the term company for convenience, but it's obviously wider than just companies. But the company itself has its own legal identity. So that when the company is created, and there's a process that has to be followed to create the company, to incorporate the company, once it's created, it is a living individual in the eyes of the law. And that means that the company, rather than the people involved in running the company, can own assets, it can enter into contracts in its own name, it can employ people. And if there's a liability attaching to that, it's the liability of the company and not the liability of the people who are involved. So whether that's the directors of the company, whether it's employees in the company, or indeed members of the company, they don't take on a personal responsibility for the actions of the company. It's the company itself. And that means that if for any reason a debt arises and the company can't pay that debt, it is the company that becomes insolvent, not the individuals involved. They have a degree of protection, a degree of limited liability. And exactly what that liability is will depend on the particular structure that you use, whether it's a share company, whether it's a guarantee company. And again, I'll touch on some of those differences in a few minutes. So moving back to our list, types of legal forms. As I say, as you move down the list, you follow a kind of timeline, but you also now, having moved beyond the unincorporated structures, you start to move into the incorporated bodies, the industrial and society, the companies, the community interest companies, the limited liability partnerships. And I'm now going to go through each of those in turn and identify what the differences are and again what the advantages and disadvantages are. The Industrial Employment Society, as I say, touch on this one first. It's the oldest. It's been around for a good couple of hundred years now, so around long before the companies ever came into existence. In the current structure of an industrial employment society, there are two forms. There's what's called the Society for the Benefit of the Community, or the BENCOM for short, or the cooperative. Now, hopefully everyone will have heard of the term cooperative. I'm not suggesting that the Industrial Employment Society is the only structure that cooperatives can use. Indeed, cooperatives can use any of the legal structures that are available. Cooperative is, again, a status issue. But the Industrial Employment Society has a particular model designed specifically as being suitable for cooperatives. In order to register, whether it's as a society for the benefit of the community or as a cooperative, there are formalities, and that means that you need to fill in relevant paperwork, and you file that paperwork with the Financial Services Authority. This is just a peculiarity that's arisen out of history, I'm afraid. Whether or not it's appropriate to be registered with the FSA is an ongoing dialogue with the central government, but that's where we are at the moment. It does not mean that industrial and provident societies are regulated by the Financial Services Authority. The Financial Services Authority has a particular role for regulating financial activities under the Financial Services Act, and only if the industrial and provident society is engaging in those activities will it actually be regulated by the FSA. So it has a registration purpose, very similar to the role of Companies House, which means that when the paperwork is filed, the FSA put it on file and it is a public document. Unfortunately, the FSA are not as sophisticated or as up-to-date as Companies House, which means that it can be rather difficult to get hold of the relevant papers to deal with any particular industrial and provident society. It used to take 30 days to search the FSA register to get a copy of the constitution of an industrial provident society. For those of you familiar with companies, you'll appreciate you can get straight onto Companies House and you can access documents in a matter of seconds using the web access facilities at Companies House. So there is an issue here over how transparent the industrial and provident society is, and it has suffered in comparison to companies. And it's one of the reasons it's not as well known or indeed as well used as companies, because it is harder to deal with the administrative aspects of the industrial and provident society. I mentioned that there were two types, the society, the benefit of the community, and the cooperatives. I'll deal first with the cooperatives, as that may be a more familiar term. There is nothing special in terms of registering an industrial provident society as a cooperative. You simply need to make it clear when you register that that is what you intend, and that your particular industrial provident society will abide by the cooperative principles. I'm afraid that's a tick box exercise on the relative form. The society, the benefit of the community, is very similar. As its name suggests, it is there for the benefit of the community, and this is the early form of vehicle suited for social enterprises. When you file the relevant papers with the Industrial and Provident Society to register your society for the benefit of the community, you will simply tick the box that says you wish to be a society for the benefit of the community. Now, you are required, though, to state why you don't feel registering as a company would be a more appropriate route. It's not a onerous requirement. You simply need to follow through the principles that deal with issues of community benefit. The difference between a company and a society for the benefit of the community isn't, I'm afraid, one of regulation. It's entirely possible for a social enterprise to be a company as it is for it to be an industrial provident society. But by adhering to democratic principles, you explain the difference why an industrial provident society might be appropriate for you. Now, an industrial provident society can be charitable if it is a BENCOM. It can pay interest, or sometimes referred to, but improperly referred to, as dividends on shares. The Industrial Provident Society is a share company. What that means is that the members of the society, when they establish the rules, agree that they will take a number of shares in support of their membership. It's not an investment as such, because the shares are normally valued at £1. They can have different classes of shares. When, in terms of the different classes of shares, there is a particular feature about the society which I'll refer to in a moment. But the shares are simply that certificate of membership entitling the members to have an interest in the society itself. If you have 100 members, each having one share each, you have 100 shares, and ultimately those members own the particular society. And if the society was ever to be wound up, then the assets of that society are distributed amongst the members, and it's very easy when you have a share structure to identify what each member's interest in that particular society may be. And the same principles flow through to companies that have a share structure as well. And as I say, one of the principles of the societies is they're democratic. It doesn't matter how many shares you have, it's always one share, one vote. Now, in terms of the registration process, as I say, there is a set of rules that are agreed by the members and filed with the Financial Services Authority. The registration costs are significantly higher than for a company. By way of example, to register a new society, whether it's a cooperative or a society for the benefit of the community, would cost you in the region of £1,000 in terms of registration fees. That compares to Companies House online registration for £10. I've touched on the fact that it's less transparent. There are limits in relation to the ownership within a society. At the present time, there's a maximum of £20,000 worth of share capital that any individual can have. That is intended to reflect the fact that the society is intended to be democratic. So it doesn't matter if you do have £20,000 worth of share capital, you still only have one vote. The two principal types of shares that exist in an industrial province society, in particular the Society for Benefit of the Community, the BENCOM, are withdrawable and transferable shares. Again, these are reflected in company structures that have share capital, but there's a particular feature of withdrawable shares in industrial province societies, and that is that within the financial promotions regulations, there are various exemptions for share issues that are made by societies. There are limits and prohibitions on companies issuing shares to the public. If a company limited by share wishes to issue shares, it has to issue a prospectus. The Industrial Province Society has got exemptions through a great many of those regulations, and that makes the Industrial Province Society particularly suitable for any enterprise that is looking to raise capital from the public, provided it meets the requirements of being a society for the benefit of the community. And this is why this particular structure is used often for renewable energy projects. So community wind farms, any other kind of renewable energy project will use an industrial province society because it has those exemptions, it can go out to a wide pool of investors, and it can invite investments. And usually in those kind of projects, individual investments of up to £20,000 are quite feasible. It's not a problem. You rarely have individuals who wish to invest more than that particular limit. So that's one of the particular features of the Industrial Province Society, the Society for the Benefit of the Community in particular, and that's its accessibility in a democratic fashion to a wide pool of potential investors for social purposes. That's obviously not suited to every project. So moving to the company limited by shares or the public limited company. Now, company limited by shares is by far the most familiar type of legal structure that you will come across. The vast majority of businesses that you will come into contact with will use the share structure. Why? Because it is so easy, so convenient, and so flexible. You register with the Companies House, and what you register is the rules, which for a company are called the Memorandum and Articles of Association. Those set out all the same things that I mentioned with the Unincorporated Association about who the members are, how the members get elected into the particular company, what the purpose of the company, what its objects are, who's going to run the company, in this case the directors, what powers those directors have. All of those provisions are set out in the members' agreement, the members' rules, which are called the Memorandum and Articles of Association. You file those at Companies House, and as I've mentioned, you can do it online for as little as £10 or by paper for £40, and there are a great number of company formation agents available on the internet that will offer you a very simple process and assistance in becoming incorporated. It is important that you differentiate between the different roles that exist in any company. Most of the structures I'm talking about, in fact, all but the very last, have what's called a two-tier level of governance. That means they have members and directors. Now, the members and directors may take different names. In charities, they're often referred to, rather than as directors, they're referred to as trustees, but they will have two levels of governance. The way in which the company is structured is a group of individuals, the members, will come together with a view to setting up this structure to carry out activities on their behalf. So the members agree a set of rules, which are the articles. Those articles will then delegate certain powers, certain responsibilities from the members who control everything to the directors. So in a traditional company, the directors are intended to carry out the instruction of the members, and that's embedded in the Companies Act legislation as well, that the members can force meetings, they can impose resolutions, and they can direct the directors in terms of what they can do. Now, that pure approach is obviously watered down the more members exist, because members work on a majority basis. Sometimes you require a special majority, but for most company issues, most resolutions that members wish to pass to instruct directors, you work on the basis of a simple majority, 50%. And if 50% of the members agree, then they can direct the company accordingly. Certain matters are reserved to special majority, but usually those are constitutional matters, so changing the Constitution, changing the Articles of Association require a 75% majority. Now, the fewer members, the easier it is for those members to control what the company does. The more members, then the less control. And that's one of the issues between local companies and multinational companies in terms of the power of members. But it's also important to remember that once the members have delegated that power to directors, it is for the directors to carry it out. The members have no authority once they have set the rules in place. Once the articles are there that delegate the day-to-day running of a company to the directors, that is the role of the directors. And that's something members need to remember. If members want to give instructions to the directors, they have to follow the constitutional framework. If they overstep that and start to directly interfere with the management of the company, then they may be taking on the role of a director, and that carries with it responsibilities. Now, the directors, as I say, are delegated with that responsibility, but they are governed by many provisions in the company's legislation that says how or why they should be doing certain things. And if they get some things wrong, particularly around environmental laws, employment laws, corporate manslaughter rules, then the directors can be held personally to account. Now, please remember that when I spoke about incorporated structures, I made reference to limited liability. It is not the case that those involved in a company have free hand in what they do and cannot be held accountable. There are obviously issues about how effective certain laws are, particularly around corporate manslaughter, in holding individuals to account, but laws do exist and can impose liability directly on individuals where they have acted otherwise than in accordance with the constitutional framework, or have acted in some way that the law insists that they are held personally accountable. Now, because the articles is that contract between the members, again, it is very flexible. And it's up to the members to decide how they want to arrange their particular relationship. It's possible, indeed many companies have, different classes of shares, in effect different classes of membership. And those different classes can carry with them different rights. Now, in shares are one of the means by which money can be invested in a company, but also one of the ways in which money can be distributed out of a company. And it's possible because you can assign different rights and obligations to the shares, to assign different rights and responsibilities in relation to what's invested and what someone might be able to receive from the company. So that means, for example, that you can have preference shares, which allows certain shareholders who hold designated shares to receive dividends in advance of other members. You can have shares that carry no voting rights, so that the shareholders are only entitled to receive distributions of profit if indeed any are made. It's entirely flexible, and that flexible means that the company limited by shares is very suitable for the vast majority of activities. It is entirely possible to have a company limited by shares which is a charity. It can be difficult to establish it because the concept behind shares is personal ownership, that a member owns that share, and therefore there's a question over public benefit. But if having a company limited by shares was necessary for your particular purpose, you can have a charitable company. Again, you can certainly have a social enterprise that exists by way of a company limited by shares. The difficulty there is, again, the personal nature of shares, the personal ownership, the personal benefit is one that casts a shadow of doubt by others looking at a company limited by shares as to whether it is truly a social enterprise. But again, that's one of perception rather than necessarily structure. The company limited by shares is very, very flexible. Now, I mentioned when I touched on one of the benefits of the Industrial and Provident Society that a company limited by shares is not permitted to offer shares to the public. Now, there is case law on exactly what that means. What is the public? So a company that can identify a group of high net worth individuals or key investors where you're talking about 10, 20, maybe even 30 individuals isn't making an offer to the public if it's going direct to those individuals. But if you wanted to raise money for a community purpose, or you wanted to raise money that needed a large investment from a large body of individual members of the public, you're not permitted to do it using the company limited by share structure. It's illegal, and I'm afraid penalties under the Companies Act are both fines and imprisonment. So there is a structure that allows you to do that, which is the public limited by company. It has exactly the same structure as a share company. It's governed by its memorandum and articles of association. It's registered with Companies House, but it has some slight differences, and those differences are what defines it as a public limited company. So it must have a minimum of £50,000 worth of paid up capital. Now, the advantage of the public limited company is that it is allowed to go out to the public to raise capital if that's what you want to do. However, in order to do so, it has to comply with quite stringent financial services legislation, in particular prospectus rules, and there's quite a complex process, quite a costly process to go through in order to put together a prospectus which allows the PLC structure to go to the public. It's all about public protection. That cost under the PLC structure, again, is one of the reasons why Society for the Benefit of the Community as an industrial provident society is a very convenient structure for community projects. Now, having shares in a company does make it easier to leave the company but to extract value. And what I mean by that is if you own shares in the company, usually, but not always, they are transferable. So you have the right, under the articles, and the articles can be changed, to transfer those shares to somebody else. And that means that you can effectively sell your interest in any particular company. What's that worth is dependent on what anybody is willing to pay, but obviously there are certain markets out there that allow shares to be easily traded. Again, there are restrictions about what type of companies can access some of these particular markets. So the one that people will recognize in terms of the FTSE and the international markets, only public limited companies are able to join those markets. They're not required to join those markets, but they're the only ones eligible to join those markets and publicly trade their shares. And that's one, again, the features of the share company, that if you're investing in a business and looking at the long-term return, you're going to want to have as easy an exit as possible, and the shares allow that. subject to the rules that impose any restrictions. The company by guarantee follows more or less the same structure as the share. It's again governed by its constitution, its articles, which is the contract between the members. It's registered with the Companies House. The significant difference, as the name entitles, is that it doesn't actually have any shares. What it has is this guarantee. And the guarantee acts in a similar way to the shares in that when the members set the company up, when they agree the articles, they put a provision in it which says that if the company is for any reason unable to pay its debts and therefore heading into some form of liquidation, if the company can't pay its debts, then the members will have some degree of liability. Another feature of limited liability. In a guarantee company, it's very often that the members agree that if there are debts of the company after it's been wound up, they will contribute a sum of, and it's perfectly permissible to put a cap. Indeed, it's very much recommended that people put a cap of what that guarantee is. It used to be £1. More often now it's £10. It can be anything. And what that is setting is the extent of the liability of the members. So long as the members have behaved themselves, followed the Constitution, followed the legal framework that exists for companies, in particular the Companies Act, then they will be protected, and the extent of their liability for the debts of the company that they have set up and to all intents and purposes owned and controlled will be the value of their guarantee. And that applies in the share company as well. So shares have a value. Very often it's a £1 share. So the extent of the liability of the members holding the shares, if that company is ever wound up, if it goes into liquidation because it's unable to pay its debts, the members can be called upon to contribute. The value that the members can contribute in a share company will be limited by the value of the share. So if it's a £1 share, that's the amount that they would have to contribute. If they have 10 shares, it's a contribution of £1 per share up to £10. Now, ordinarily, when shares are issued, the company will receive some consideration, some money for that share. So usually when a share is issued, the value of the share is paid up, so that the first holder of that share will have paid their £1, the company will have received that money, and that means that where the share has been fully paid up in that way, there's no contingent liability on the members. So if that member transfers shares to another member, and so on, at a point at which, if ever, the members are called upon to contribute, they may have nothing to contribute because the amount actually due on that share was paid when it was originally issued. Now, what that also means for the guarantee company is that it is not as easy as a share company to distribute profits. When a share company distributes profits, it can work out how many members it's got and how many shares they have. And if it's a pro rata, very straightforward, or the shares carry certain rights, so some people will get their payment first, others may not be entitled to any. But it's very flexible, so different individuals can gain different amounts. In a guarantee company, it is still possible to distribute the profits, but it's to all the members equally. So it's less flexible, but still entitles members under a guarantee company to receive some form of distribution. Now, the guarantee company is actually one of the more popular legal structures used for charities. One of the features of a charity is that the members are not entitled to receive any kind of distribution. Even if the company is wound up and there are assets left over, if it's charitable, then part of the agreement between the members enshrined in the articles is that members do not receive any kind of distribution. That means that the guarantee company has to be modified for charitable companies. The traditional company by guarantee doesn't have that restriction. It's a special modification that applies for charitable companies, and it also is used where social enterprises are using the company limited by guarantee, where again there's an expectation that members will not personally benefit. It's just a simple change to the rules that the members have agreed in the articles. Now, one of the difficulties is that that particular change to the articles is simply an agreement between the members. And for a long time it was appreciated that if members can put that rule in, then working by the special majority, the 75%, they can take it out. And that's one of the weaknesses of the company limited by guarantee in a social enterprise structure. There are restrictions for charities because a charitable company can't take that rule out without the consent of the Charity Commission, which the Charity Commission isn't going to give. But it means that the company limited by guarantee was rather a weak structure for social enterprises in terms of protecting assets for community purposes in the long term. And that was one of the reasons why a new structure was introduced back in 2005 following the 2004 Act, Community Interest Company. It's designed specifically for social enterprises. It uses the same structure as a guarantee company and as a share company. It's registered at Companies House. It has its Memorandum and Articles of Association. There is a regulator of CICs, which gives it some special features. One of the particular issues is that it has this asset lock. And that means that embedded in the rules is a provision that members cannot benefit. And it's an unbreakable asset lock because it's there by statute. Now, the Community Interest Company also has other limitations that prevent returns being made to members, particularly because the Community Interest Company can take any of the company structures. It can take a share structure, it can take the guarantee, it can take the PLC. The most popular form is guarantee. There are share community interest companies. I've not yet come across a PLC version. So if anybody does know, please do just put it into the chat box. But there are other limitations on money being extracted from the community interest company, and that is that any kind of distribution through shares or otherwise through the guarantee is restricted to the value of the profits that the company is making. So if we look again, or if I just remind you about the definition of social enterprise on one of the early slides about reinvesting profits for the benefit of the community, then limiting the amount of profit that can be extracted goes towards meeting that particular definition. Now, as I say, the Community Interest Company is a vehicle that was specifically created as a modern vehicle for social enterprise. It sits alongside the Industrial Province Society, in particular the Society for the Benefit of the Community, as a fit-for-purpose model for use by social enterprise. Whether or not that fits your particular purpose is, again, down to your particular requirements, but it's there. The particular advantage of the Community Interest Company is it's gaining branding, it's gaining recognition. When people see a Community Interest Company, they can see immediately that that is a company that has protected social enterprise features within it. Doesn't mean to say, as I've said before, that social enterprise can't take one of the other forms. It also doesn't mean to say that you have to be a social enterprise to use the Community Interest Company, but the limitations on those distributions, the dividends and other payments that can be made to members, is a significant feature, and you should only obviously use, therefore, a Community Interest Company if those particular features are important to you. In terms of the administration, there are slightly more disclosure obligations, but only to the extent that every year, alongside all the other returns that you need to make to Companies House as part of the disclosure obligations that come as being part of a limited liability protected status, you also need to file a community interest statement which confirms that you are continuing to undertake activities for community benefit. Now, as I said at the start, it's important you give thought to what it is you want because it can be expensive to change as you go down down the line. Now this slide is here just to say that it is possible to change. If you take a company structure, whether it's a share company, a guarantee company or PLC, you can convert to a community interest company. What you can't do is convert the other way because of the asset lock provisions. You can convert between industrial property societies and community interest companies, again because those are asset locked structures in themselves. They have those limitations on member benefits. And it is possible to take a guarantee company and convert it into a share company. Again, you need to think about why you might want to do it. It does carry with it a cost. It's much better to go through the process of understanding what you may want from your company from the start. Bring us more up to date with available structures, the limited liability partnership. Now this builds on the old partnership structure, very informal structure, as I said. One of the risks of the old partnership, the legal partnership, is that you can fall into it without necessarily appreciating that that's what you are doing. The limited liability partnership is different. It follows a company model. You register with Companies House. Again, there are forms that you fill out to do so, but they're much more limited than required for companies. In particular, the form that you're filing with Companies House simply states that you wish to be a limited liability partnership. It identifies who your designated members are. They're the key contacts for Companies House purposes. There is no requirement to file with Companies House the members agreement. There's no requirement to have one, but it's always recommended that you do because, again, you need to regulate the relationship between the members to be clear what the members' role is, how members can be brought in, what the purposes, the activities, the objects of the limited liability partnership are intended to be, and how you're going to appoint your designated members, etc. So all the same provisions that applied when I mentioned the unincorporated association, the provisions of the articles for company, the contents of the rules for an industrial property society, you need to have those because they're there to help avoid arguments at a later stage. Now, one of the principal features of the limited liability partnership and why it is of such advantage is that it's tax transparent. This makes it an ideal joint venture vehicle. So if you have multiple parties coming together for a particular project and they want to share the profits, the surpluses that are generated in that particular activity, the limited liability partnership allows them to do it in a tax efficient way because the income is taxed in the hands of the members, not in the company structure. With a traditional company, whether it's an industrial property society, whether it's a guarantee or share company or community interest company, when the company makes a profit, it gets taxed. When it distributes that profit to its members, however it may do that, it gets taxed. And when the members receive those profits, they get taxed as well. Now, there are offsets that apply, but with the limited liability partnership, it's much simpler than that, because when the profits are made within the limited liability partnership, they're allocated to the members, and the members get taxed on an individual basis. So you only get hit for the tax at the point of the allocation to members. It can be a significant saving, and limited liability partnerships are being used in all different areas, including for charities, social enterprises, and indeed for individual family members. It's a vehicle that is very flexible. The Charitable Incorporated Organisation, as I say, this one is now expected to have regulations out in the middle of the month, so we're expecting from the middle of the month this to be available to those who wish it. One of the features of a charity, and I mentioned that charity isn't a legal status, it's a what you do and do you satisfy the definition. But with a charity, particularly one that uses a company structure, as many do, if it sets up, incorporates the company limited by a guarantee, it needs to register with Companies House, and it has all of its filing obligation, disclosure obligations under the Companies Acts with Companies House. But as a charity, it also needs to register with the Charity Commission, and it has all of its filing obligations and disclosure obligations with the Charity Commission. And unfortunately, the two are not the same. So they're making the same information available in different formats at different times to different registrars. The Charitable Incorporated Organisation is intended to do away with that. It's a legal structure specifically for charities, registered with the Charity Commission in a similar way that the Community Interest Company is a vehicle specifically for social enterprises registered with Companies House. So hopefully that will make the life easier for many charities. Again, whether or not that's suitable for your particular purposes, it's now an option that is available for you. So I've run through the principal legal structures that are available. There are others, I'm afraid, particularly with the European context and companies that may have cross-border activities, but I won't go into those. As a sort of general guide for you, I've touched on a number of principles in relation to each of the vehicles that I've touched on, each of the legal structures. Key feature for you in considering which legal form might be appropriate is this element of risk. That's the difference between your unincorporated and your incorporated structure. And the recommendation would have to be, if there's risk, you must look at an incorporated structure. Finance is one of the other key indicators. Where is your money coming from? Is it coming from trading activity? Well, any of these organizations can trade. But are you reliant upon some other source of funding? Are you reliant upon grants, which means you need a structure that is acceptable to the grant makers? So you're looking there more at community or public benefit structures around charities or social enterprise. Are you looking at raising money from a wide community, in which case you're looking at your industrial provident society because of the advantages that that brings in financial services and financial promotions restrictions? Are you looking for high value investors who will come in, invest and expect an exit within a short window, in which case you need flexibility of the traditional company limited by share structure? Now all of these structures, as I say, can trade. There are some restrictions that apply to charity trading, but it can still trade. They can all access loans. So again, are any of those financial considerations relevant to you? Look at your long-term strategy. What is it that you intend doing in 5, 10, 15 years' time, and will the structure that you're considering be suitable for that time frame? Do you want charitable status? That will push you in a particular direction. Again, consideration here of what it is you want to do and making the structure fit you rather than simply taking the first structure that is available. And one of the keys and one of the areas that I do a lot of work in is around group structures. Bringing these different vehicles together, because for some activities you may be engaged in, an industrial provident society may be suitable, a community interest company may be suitable, a charity may be suitable, and you can bring these different structures together as part of a group. So you always have that as an option. Now that completes the main matters that I wanted to raise with you. I'm going to just throw up a few slides now talking again about this status versus form issue. But it's an opportunity, please, if you do have any questions, to start typing them in now, as we are drawing to a close on the webinar with about 5 minutes to go. Now, as I said, status versus form. It's important not to get the two confused. Community amateur sports clubs can exist as unincorporated associations, can exist as social enterprises. They'll often adopt the company limited by guarantee, or indeed the community interest company limited by guarantee structure. There are certain advantages if you gain community amateur sports club status, and that's done through registering with HMRC. You can get gift aid, you get certain tax exemptions. Again, recognizing that there is a status and flexibility of the legal form that comes with it. Community development finance institutions, those who haven't come across these particular vehicles, they're like it's microfinance in many senses, lending into local communities either on an individual or business basis, particularly those areas that traditional high street banks are unable to service. One of their features is that they seek to raise significant funds from community of interest, the public at large, and therefore the Industrial Pomp Society, with the advantages of the financial promotions legislation, gives them a particular advantage so that they can do their work. And one of the things to recognise is that investments that are made, so if you do buy shares in an Industrial Pomp Society, again, depending on the particular structure, there are certain tax reliefs available, whether it's a community investment tax relief or enterprise investment schemes. Community land trusts, again, some of you may have come across these. They buy land for affordable housing on a community basis. And again, they will use the Industrial Pomp Society model where they need to raise significant capital. They will take the company limited by guarantee or the community interest company model because of its social enterprise focus. That's the end of my presentation, so thank you very much for listening. I think I need to hand back over to Julie.
Yeah, we do have a few questions, Chris.
Okay.
If you can hear me okay. We've had some good questions come through. First of all, I just want to remind everybody that I am able to send this PowerPoint presentation out after this webinar, so you can refer back to all the different types of legal structures. And we've also recorded this webinar so you can listen in, because I appreciate there's quite a lot of information to take in, and it's very, very detailed. So there is the opportunity for you to refer back after this webinar as well, which I think you will find helpful. So I'm just going to fire in a few questions which have come through, and please, for the next couple of minutes, if you have any more questions, please shout them through. But we've been asked, Chris, which is the most appropriate legal structures to secure social investment?
Social investment suggests shares, which pushes you towards the Industrial Pomp Society as a share structure or the community interest company limited by shares. Now, for investment purposes, the Industrial Pomp Society is long-term. It takes an awful long time really for a return. If it is intended as a short term, you need flexibility, and that's perhaps more the community interest company limited by share. The difficulty is that even though the share model of the community interest company exists, its perception is still tainted by that share structure. There's also the disadvantage that the cap on return often makes it unattractive to investors. So I'm afraid it's one of those issues that you probably need to discuss with your potential investors, what it is they're hoping to get. If I were going for a long-term capital investment like a wind farm or a community building, then the Industrial Pomp Society would be more appropriate because it doesn't have those limitations on how much you can return to your social investors. Hopefully that sort of answers that.
That's great. Now, another question that's come up is about being a sole trader
Yes.
as one of the options. And if you had any comments on that, yeah.
The sole trader sort of is one of those that would come at the top of that list of legal structures that I suggested. It's not a legal structure at all. It's just you. And the feature of being a sole trader is that you have responsibility for everything that you are doing. So in a similar way that an unincorporated association imposes a potential personal liability, so does operating as a sole trader. What every sole trader needs to consider is, where does the risk lie, and when does the risk reach a point at which it is better for you to incorporate as a company. And if it's a sole trader and you're trading for your own benefit, then the company limited by shares would be the vehicle that you would be looking at. It does come down to that liability issue, but the difficulty with the way in which many banks approach the situation is if you're reliant upon bank funding at any stage, banks are not too concerned about the legal status of companies because they will ask the members or directors of a company to give personal guarantees. key triggers for moving from a personal liability to an incorporated structure will be the significant value of the risk that you've taken on, particularly around employment. The liabilities that come with employment risks nowadays mean that if you start employing anybody as a sole trader, you must look at an incorporated structure, and the one you'd look at is the company limited by shares.
Great. Okay. One final question about the transition from an unincorporated association to a registered charity rather than a CIC.
Yes.
And perhaps some pros and cons of this.
Okay. Well, in strict legal terms, I'm afraid there is no transition, because what you are required to do is establish a new vehicle as a charitable company. So I'm not quite clear whether the question is moving from an unincorporated association to an unincorporated charitable association or to a charity. So I'll quickly deal with both. Most often we deal with the latter, which is an unincorporated association, a charitable association that wants to incorporate to gain protection of the limited liability status. And as I say, what you do in technical terms there is you have to establish your new company. It's a completely new, separate legal personality. You register that with the Charity Commission, and effectively you transfer everything from the old association to the new. And there's no transition at all. It's old and new, and then you just close down the old. If you're trying to transfer what is a general association into a charitable association, it is actually quite difficult, because you have to persuade the Charity Commission that your activities were always charitable. If they weren't before, why are they now? If they're not wholly charitable, then you're not a charity. That's the definition of a charity. So in many cases that we've come across where an organization has changed its direction and wants to be wholly charitable, it's actually been told by the Charity Commission, you need to set up a new association, close down the old one, transfer everything over, so that the charitable structure isn't tainted by any non-charitable activity that has been carried on previously.
Great. Two more questions.
That covers both angles.
Thank you for that. Just two more questions which have come through. Somebody is asking about good governance, and what exactly is good governance?
Good governance, I touched on the issue that in order to retain the protection that the law provides to the incorporated structure and under charities legislation, you have to follow the rules. You have to follow your articles. You have to follow the statutory framework in which you operate. So that's one of the basic elements of good governance. Good governance simply means doing it properly. So whatever your governance structure is, make sure you're following your constitution, following your charitable purposes, and complying with the Charities Act. Now, good governance actually goes much deeper than that, because it talks about the way in which the trustees of the organization actually work with staff members, making sure they get the right advice at the right time, that they consider that advice, that they're aware and deal with conflict of issue situations. So good governance is quite a wide term for proper governance, or in another way of looking at it is trustees protecting themselves from any reputational or financial risk.
Great, thank you. And finally, last question that's come in as how much does it cost to set up a CIC? So what would be the legal and any kind of advice costs?
£35 for Companies House. What I would say is that the CICs are slightly easier, because you can go to the CIC regulator's website and get model constitutions for different kinds of CICs. And if you use that and fill in the paperwork, file it with Companies House, you're simply paying for the Company House registration costs, which will, with the CIC fees, will cost you about £45. Now obviously when you start to introduce the lawyers, it can get more complicated. It really does depend on what you need. So for example, we tend to, when we are working with CICs, it's because they are more complicated than using the templates that are available. Our average costs for setting one up would be in the region of about £1,500, and that's because we're going through a lot of discussions with the potential members, the potential directors, about the roles and responsibilities, making sure that it's fit for purpose.